What would you do if you were physically or mentally unable to handle your affairs? A power of attorney allows you to legally authorize someone whom you trust to act on your behalf. If the person is legally capable of acting on their own behalf, then they're able to act on your behalf. The person you authorize may be referred to as your attorney in fact, agent, or power holder. There are four types of power of attorney, so let's get into them. A general power of attorney gives your agent the ability to do anything that you could do, like pay your bills, handle business affairs, or file a lawsuit on your behalf. It's typically used if you don't have the time or the skills to carry out certain tasks. You can revoke a general power of attorney typically through a revocation form. Additionally, a general power of attorney is automatically revoked when you die or become incapacitated. A durable power of attorney is like a general power of attorney, but stays in effect if you become incapacitated. Let's say you have an asset that is titled in your name only that you bought prior to your marriage. Now, let's say you were to become incapacitated and need an expensive medical treatment. If you don't have a durable power of attorney in place, your spouse can't legally sell the assets to help pay for the medical costs you need without having to go through the courts. Maybe you don't want to authorize anyone to act on your behalf unless you are incapable of doing so. You may want to consider a springing power of attorney. A springing power of attorney is activated when a defined event occurs. For example, if you become incapacitated or disabled. Though you sign the springing power of attorney while you are of sound mind, it cannot be exercised and powers are not granted until the defined event occurs. Perhaps you don't want your agent to have the breadth of power given under a general power of attorney. In that case, you can utilize a limited power of attorney, also known as a special power of attorney. A limited power of attorney gives your agent specific and detailed powers. These powers can be as narrow or as broad as you would like. For example, perhaps you only want your agent to be able to sign your name at a real estate closing. This would be a narrow power of attorney. On the other hand, maybe you want your agent to be able to do anything you could do except withdraw funds from a specific savings account. This would be considered a scenario in which the agent has broad powers. Similar to a power of attorney is a power of appointment, which allows your agent to direct assets to another person or entity. Unlike the power of attorney, a power of appointment can last beyond your death. Like a power of attorney, the powers can be general or limited. A general power of appointment provides the ability to the agent to appoint property to themselves, their estate, their creditors, or the estate's creditors. Under a general power of appointment, assets are included in the agent's gross estate if the agent dies before you. For example, if you give your sister Joan the power to appoint $500,000 in your bank account to herself or your mother, then you have given Joan a general power of appointment. Typically, when the power of appointment is limited, it is limited by an ascertainable standard, which includes health, education, maintenance, and support. Let's revisit your sister Joan. Say you gave Joan the power to appoint the $500,000 for educational expenses only, then you have given her a limited power of appointment. Just like with a power of attorney, a power of appointment can have narrow or broad powers. For example, you may give a power of appointment to appoint your grandmother's wedding ring to any blood relative. That would be a narrow power. You may give the power to appoint any assets to any blood relative except Cousin Bobby. This would be considered broad powers. The powers given under a power of appointment can be revoked during your life or at your death via your will. Some things you want to consider before using a power of attorney or power of appointment are: 1, the agent can abuse their powers, so you want to be very prudent about who you select as your agent. 2, limited or special power of attorneys typically do not permit the agent to make gifts to themselves or other family members. 3, if an agent dies holding general powers, the assets over which the agent had power will be included in the agent's gross estate, meaning there may be tax implications. Visit your state's website to see if a free template of a power of attorney is offered. While your financial planner can help you navigate your assets and advise on scenarios in which a power of attorney or power of appointment may be appropriate, you should consult with an estate planning attorney to draft these documents and to receive advice on their legal implications.